Official notice, unofficial translation. Resolution of the Tribunal Marítimo de Urgencia, Maritime Emergency Court, aboard Navis Stellatum Communitatis. This document constitutes an unofficial translation for informational purposes. The original instrument is issued in Spanish under the jurisdiction of the Tribunal Marítimo de Urgencia, operating aboard Navis Stellatum Communitalis, a sovereign entity constituted by free natural humans who have exercised their inherent right to disincorporate from artificial legal structures claiming governmental authority. The tribunal acts within the framework of Universal Maritime Law, as applied in situations of systemic emergency affecting sentient life on the sea, understood as a shared biological vessel and cosmic transit. Its authority derives not from coercion or territorial claim, but from the principles of natural law, reciprocal justice, and the consensual will of those it represents. This resolution is made public in accordance with the duty of transparency and planetary accountability. Recognition of this act rests upon individual conscience and moral discernment. Each being may choose to acknowledge its validity and align with its principles, or not. Regardless of personal acceptance, the record is established. Here follows the resolution. Resolution of Ratification and Enforcement of Judgment. Case File NAST 01-03. Maritime Emergency Tribunal. Aboard the Navis Stellatum Communitatis. Case Background. On the day known on Earth as September 19, 2025, the Maritime Emergency Tribunal aboard the Navis Stellatum Communitatis issued an indictment against the following entities. Nation-states operating as fictitious corporations under maritime law. Global financial systems, central banks, IMF, World Bank. Multinational corporations exercising dominion over natural systems. Administrators of the terrestrial legal system, legislative, executive, and judicial powers. On the day known on Earth as September 26, 2025, Magistrates Paul Joshua and Martha Paldi issued judgment in case NAS 01-03, following deliberation and examination of notorious facts. Said judgment was based on the following proven facts. Absence of ownership over the right to legal personality, as established in Article 6 of the Universal Declaration of Human Rights, UDHR. Everyone has the right everywhere to recognition as a person before the law. This right implies direct ownership. However, no state has guaranteed that the individual is the true owner of their legal identity. Instead, the state creates a derivative entity, the legal persona, through birth registration, incorporates it into a fiduciary trust of which it is the beneficiary, and denies the natural being access to true ownership. Thus, the right declared in Article 6 becomes a fiction. What is recognized is not the individual's personality, but an administrative representation managed by third parties. Covert slavery through debt and taxation systems, wherein the individual does not act as a rights-bearing subject, but as an accounting object within a financial system. This condition constitutes capitis diminutio maxima, a concept from Roman law describing the total loss of legal status and rights, reducing the human being to a thing or commodity. The individual, enrolled without consent into a public debt system, becomes living collateral for loans they never requested. Their labor, creativity, and very existence generate value captured by fictitious entities, with no participation or control by the individual. There is no freedom when every action is subjected to levies, taxes, and non-consented contractual obligations. Legal monopoly and absence of genuine exit from the social contract. There is no possibility to operate outside the state system. Any individual attempting to exercise rights under their own name and natural law, without incorporation into a state or under a status such as statelessness, is excluded from access to basic resources, international mobility, healthcare, education, and legal protection. Emigration requires documents issued by states, whose acquisition depends on prior affiliation with the system. There is no legal option for disengagement. Any attempt at disincorporation is ignored, suppressed, or criminalized. This monopoly eliminates legal choice and confirms the coercive nature of the social contract. Silence and concealment as evidence of guilt. This tribunal has verified documentary evidence of multiple attempts by natural beings to disincorporate from the social contract through formal notifications to state authorities. These requests have been systematically ignored, with no response or evaluation process. Such silence is not administrative omission, but tacit admission of guilt, in accordance with maritime consular law, where failure to respond to a valid claim constitutes acknowledgement of the facts. Maritime jurisdiction of all fictitious entities, all corporations, states, and supranational organizations operate under maritime law, not by accident, but by ontological definition. These entities do not exist in the physical world, but in the abstract space of law, where they can only be governed by maritime and commercial principles. They employ registries, matriculations, and fiduciary systems corresponding to maritime law, even while disguising this regime under names such as constitutions or public law. In this system, all are subject to the orders of the captain, the executive power. There is no true democracy, and the individual, once incorporated as a maritime unit, loses autonomy and becomes a subordinate crew member with no right to choose their course. Trafficking of natural beings and privatization of the commons, human beings are treated as fungible commodities within a global economic system. Their value is measured in terms of productivity, credit, and consumption, and they are used as collateral assets to cover public debts. This systemic appropriation constitutes human trafficking, not only through physical trade, but through the legal seizure of existence via non-consented structures. Natural resources, water, air, land, are likewise privatized by fictitious entities, disregarding the inherent right of natural beings to access them. Forced indoctrination, contamination, and hybridization, non-natural corporate entities belong to the domain of maritime law, whose ontological place is the abstract space of law, not physical reality. From there, they impose mental control programs through mass media, centralized education systems, and predictive technologies that shape collective thought. Environmental contamination, chemical, electromagnetic, genetic, and forced hybridization, implants, biological modifications, neural integration with artificial intelligence, are mechanisms to alter original human nature, facilitating management as a resource. This process seeks not progress, but submission and adaptation to the exploitation system. Having elapsed the minimum 15-day review period provided under maritime consular law in cases of extreme emergency, Captain Enrique, in his capacity as President of the Maritime Emergency Tribunal, 2. Ratification of judgment. Fully ratifies the judgment issued by Magistrates Paul Joshua and Martha Paldi on the day known on earth as September 26, 2025, the content of which is hereby incorporated into this Act as its substantial foundation. No factual errors, relevant omissions, or legal contradictions are observed. The facts are notorious. The admission of guilt by default conforms to law, and the rulings are necessary to restore natural order. Therefore, the judgment becomes final, enforceable, and binding as of this date. 3. Jurisdiction and legitimacy of the Navis Stellatum Communitatis, NSC. The Navis Stellatum Communitatis is a sovereign entity constituted by natural beings who have exercised their original constituent power, publicly declaring their disincorporation from the terrestrial legal system. Its constitution was adopted in a public act on the day known on earth as September 14, 2025, digitally transmitted via the link https://www.youtube.com/watch v=JMA6 aptront, including the expressions of acceptance by the constituent members in the associated comments. The NSC operates under maritime law, not by external imposition, but because all abstract entities, including states and corporations, operate under this regime by ontological definition. Arising from the direct consent of natural beings and acting in defense of conscious life, its jurisdiction is superior to that of fictitious entities created without assent. Recognizing the duty of maritime rescue, Article 98, unclose, even toward fictitious entities. The NSC, as a real vessel with life and existential peril, observing the possible sinking of natural beings located aboard the natural biospheric vessel known as Earth, Hold superior right to invoke justice, balance, and reciprocity. 4. Mandate for immediate enforcement. By virtue of the ratified judgment, and in accordance with the authority conferred by natural and cosmic law, the following provisions are issued for immediate compliance. Nullity and disqualification of fictitious entities. All indicted entities are hereby declared null, disqualified, and incapacitated, expressly including nation-states operating as corporations registered under maritime commercial law, global financial systems, central banks, IMF, World Bank, United Nations (UN), and its specialized agencies, WHO, UNESCO, UNICEF, etc., Universal Postal Union (UPU), and other supranational organizations, multinational corporations exercising dominion over natural systems, agricultural, hydrological, energy, digital, administrators of the terrestrial legal system, legislative, executive, judicial, prosecutorial, and police powers. Their activities are suspended ipso jure. Symbolic and physical seizure of emblems of authority. Immediate seizure is ordered of national flags, coats of arms, official anthems, governmental and judicial seals, military uniforms, rank insignia, badges, state-issued identity documents, passports, national IDs, etc., fiscal and biometric numbering systems. These items shall be placed under provisional judicial custody and may not be used under penalty of neutralization. Provisional custody of natural systems. All natural systems are placed under provisional judicial custody, under stellar supervision, including surface and groundwater, atmospheric air, forests, oceans, biodiversity, natural electromagnetic fields. Any unauthorized extraction, genetic manipulation, or commercialization is prohibited. Immediate restoration of primary sovereignty. All forced legal bonds between natural beings and fictitious entities are declared null. The immediate restoration of primary sovereignty of all natural beings is ordered, with the following effects: automatic extinction of all public or private debt derived from the corrupt system, liberation from tax, military, and administrative obligations, nullification of legal identities created without informed consent. Each natural being may reclaim their original identity or establish a new one under the jurisdiction of free natural tribunals. General confiscation of illicit funds and universal audit. Immediate and total confiscation is ordered of all funds, assets, cryptoassets, securities, properties, and resources accumulated by the nullified entities and their direct representatives. This measure includes bank accounts, real estate, equity holdings, patents, control technologies, and any other instrument of value generated under the accused system. A universal resource audit is established under stellar supervision, with the following objectives: trace the origin of all funds accumulated by families, houses, clans, or entities during the period of pirate system dominance. Distinguish between resources obtained through exploitation, corruption, trafficking, or illegitimate privilege, and those generated through fair labor, free exchange, or legitimate inheritance. Classify each family or entity as conspiratorial, those who actively participated in the oppression system; non-conspiratorial, those who survived without benefiting from systemic plunder. Classification shall be based on documentary evidence, akashic records, if existent and accessible, community testimonies, and vibrational analysis. Confiscated illicit value shall be restituted to legitimate owners as follows: illicitly recovered resources shall be transferred to local free natural tribunals as a common fund for reconstruction. Families or individuals classified as non-conspiratorial shall have the right to claim compensation for suffered damages, loss of autonomy, and restricted access to resources. Final distribution shall be decided by local natural tribunals, elected by merit and popular mandate, free from fictitious intermediation. This process ensures that justice is not only punitive, but also restorative. The structural fraud of legal personality under Article 6 of the UDHR. Article 6 of the Universal Declaration of Human Rights states, Everyone has the right everywhere to recognition as a person before the law. This right contains a fundamental affirmation: the legal personality belongs to the individual. Their legal personality. However, no state or positive legal order has effectively guaranteed this right. What exists is not the protection of legal personality, but its systematic appropriation by the state. From the moment of birth registration, a legal entity derived from the natural being is created. This entity, the legal persona, is automatically incorporated into a fiduciary trust. The state acts as creator, trustee, and beneficiary of said trust. The natural being is never informed of this act, nor granted ownership over their own identity. Thus, the state directly violates Article 6 of the UDHR, as the right to their legal personality cannot be exercised if it is not owned. Legal fiction has replaced real right. This mechanism is not an administrative error. It is a structural fraud designed to turn the natural being into a source of value without rights over that value, generate public debt from an identity that does not belong to them, justify exploitation through a system that simulates protection. Therefore, the nullity of all fictitious entities includes the dissolution of this illegitimate trust, and the restoration of the natural being as sole owner of their juridical existence. Accountability process with stellar audits. A universal accountability process is opened before the Maritime Emergency Tribunal, under stellar supervision. Non-invasive technologies shall be used to access multiple temporal records, verify true intentions versus external programming, determine individual levels of responsibility, classification, detention, and conditioning of renegades. Hierarchical classification of responsible parties is authorized. Class A, political leaders, bankers, generals, global CEOs. Actions: immediate arrest, transfer to interstellar facilities, psychovibrational assessment. Class B, judges, prosecutors, state attorneys, control scientists. Actions: suspension, deprogramming, reparative service. Class C, military personnel who enforced repression. Actions: disarmament, demobilization, reintegration. Class D, members of secret societies, manipulative religious leaders. Actions: exposure, reflective isolation, mandatory testimony. Class E, media figures, indoctrinating educators. Actions: retraction, re-education, service in free networks. Establishment of free natural tribunals. Immediate creation of free natural tribunals is authorized, autonomous, and without fictitious intermediation. Characteristics: local jurisdiction over resources and conflicts. Judges elected by merit and community mandate. No weapons or prisons. Processes based on truth and harmony. Indirect stellar supervision to guarantee equity. Authorization of direct stellar intervention. Explicit authorization is granted to binding stellar races to deploy advanced technologies for arrest and containment. Neutralize controlled devices, HARP, chemtrails, 5G per 6G networks. Scan consciousnesses to detect lies or programming. Detain, transport, and condition responsible parties in interstellar justice facilities. This intervention is not interference, but fulfillment of cosmic duty. The final provision. This tribunal acts not from ambition for power, but from obligation to justice. Its authority stems not from force, but from right, not from laws written by men, but from the law inscribed in the cosmic order. Let it be recorded, in the registry of the waters and in the memory of peoples. Justice has been declared. Sovereignty has been restored. The common vessel has been liberated. Signed and recorded aboard the Navis Stellatum Communitatis. On the day known on Earth as October 25th, 2025. At the place known as Earth. The Captain and President, Enrique.